So we can start. It's 15:04. We are incredibly punctual today. Thanks very much to all of you who are attending this nice seminar. Welcome, first of all. This is a seminar organized by the Labor Law Community, which is an association of labor lawyers based in Italy, which was born in 2020. And which aim is to connect labor lawyers from all around Europe, but I will say also beyond Europe. You can see many initiatives of the labor law community already online on their website. It's the link is in the chat, where you can see interviews, blog posts, researchers, and so on. Now, this seminar of today is devoted to a better understanding of where do we stand, so the state of play, and what are the critical points of a directive proposal that was tabled back in 2020. And it is the very famous proposal on adequate minimum wages in the EU. Now, let me briefly recall to the audience the roadmap of this proposal, which was proposed in October 2020, and then we had 2 rounds of consultations aiming at fine-tuning the text. When the Commission tabled the proposal in October 2020, the text was already rich, and then it went on in a discussion at the European Parliament, which then gave its green light with amendments, with a lot of amendments, and they started the negotiations in the trilogue. Now the works of the trilogues are still ongoing. There are rumors that this work is going to be finalized in the next weeks, if not months. So apparently this is good news in terms of the legislative process. Of course, it remains that we have a number of issues on the table which should be discussed. And the aim of today's seminar is exactly to discuss with a panel of really stellar experts the many issues that are still on the table. The rules of the game are as follows. I will briefly introduce the speakers one by one, giving the speaker around 20 minutes. So the seminar is supposed to last around 1.5 to 2 hours. There will be time towards the end to raise some questions. So in case you have, I will do my best to moderate the questions and ask the relevant speaker to answer. I would say that we can start asking the first speaker to start his presentation. The first speaker of today is Torsten MÜLLER. We all know him very well. He's a very well-known researcher working now since 10 years at ETUI. He's one of the authors of a very nice publication at ETUI, the benchmarking work in Europe. And he's a renowned expert on collective bargaining and industrial relations. So Torsten, you have around 20 minutes, and it will be interesting to get the point of view of the ETUI on this proposed directive. Thanks very much, Torsten.
Well, thank you for having me. Well, first of all, hello to everybody. It's a pleasure to be here and speak about the directive. I was asked to give a broader background view of how it came to the directive and what the objectives will be. And that's what I want or try to do within the next 20 minutes. Now, when we start to look how this directive came into being, I mean, there has been a long history of discussion about European minimum wages. But it was always something like a vision or some remote vision but it was not really on the practicalities. And I think that the picture changed a little bit in 2017 with the European Pillar of Social Rights. it was, I mean, the pillar has often been criticized for its non-binding nature, but I think it was an important normative frame of reference that also pushed the whole movement towards a directive, because if we look at Principle 6 on wages in the pillar, there is a clear commitment by the Commission and the European policymakers that workers have the right to fair wages, and that these wages should also provide a decent standard of living. And there we also hear for the first time the term adequate minimum wages, which should be ensured. And there is also already some mention of the objective that in-work poverty shall be prevented. And I think that provided an important frame of reference for the initiative that then followed. And then, of course, with Ursula von der Leyen becoming the new Commission President in 2019, there was the whole thing gathered some momentum, and there is her famous statement, which she mentioned in her agenda and the political guidelines for the next Commission, and where she actually promised that within the first 100 days, she will start an initiative to propose a legal instrument to establish fair minimum wages, and that should allow for a decent living. And then, I mean, it's interesting that Luca already mentioned the timeline, but here it is again in writing. In January and May, we had the first round of consultation. In June and September, the second ones. And then in October, the Commission actually tabled the proposal, and then there was a year-long discussion in the Parliament, but also in the Council. And in November and December last year, then they came up with their positions. And that was then the basis for the trilogue between Commission, Council, and European Parliament, and that's still going on. But I think the French presidency is very keen to finish this whole procedure within their term. And since their term ends on the 30th of June, they really want to get this done by then, which then also means that, with all the practicalities, that by the first or the second week of June, we can expect an outcome from the trilogue. And then let's see what then will be in there. Now, the objectives of the directive, obviously, one is increasing minimum wages to an adequate level. I mean, that we can gather from the title already. But I think another one, which is at least as important, is the strengthening of collective bargaining. And I think these two should be treated equally in terms of their significance. Now, and it's also important to say what the directive does not want to do, because the directive does not want to do any harmonization in terms of minimum wage levels. That means the directive does not want to establish one common minimum wage for the whole of the EU, which means, let's say, 11 euros from Sweden to Portugal, or from Poland to France. I mean, that's not what it wants to do. And it also doesn't want to harmonize the minimum wage setting. That means the directive does not want to impose statutory minimum wages on all countries. That means in those 6 countries where we have negotiated minimum wages, those countries should still be able to negotiate these minimum wages in the future. Now, to the first one, the directive does not want to establish a common minimum wage across the whole of the EU. I mean, it's obvious when we look at the different minimum wages, that's in euros, the hourly minimum wage in January 2022. And I think there it's clear we have 3 groups, one Western European group headed by Luxembourg with a minimum wage of more than 13 euros per hour, going down to Germany with 9.82. Then we have a small middle group, 2 countries with minimum wages around 6 countries. And then we have a whole big group, mainly Southern European and Eastern European countries with minimum wages below 5 euros. And it's quite clear when we look at this table that it doesn't make any sense to establish an absolute level of minimum wages across the EU. Now, what it does want to do is, or what, at least from a union point of view, would be nice, to establish a reference level of a relative level of the minimum wage. And in the directive, in one of the recitals, and it is mentioned internationally recognized standards of 60% of the national median gross wage and 50% of the national average wage. Now that should be one of the references to establish the adequacy of minimum wages. And if we look at the two tables I put up here, where we show the percentage of the median wage and the percentage of the average wage, we see that none of the countries actually fulfills both criteria, which in turn means that a minimum wage, an adequate minimum wage at 60% of the median and 50% of the average would benefit every country. I don't want to go into detail, but it's just to provide a broad reference. No country fulfills all the criteria. Now, what would happen if actually we got a directive that establishes a minimum wage at 60% of the median and 50% of the average? And I think this is quite impressive, because if the European Commission, in the context of proposing the directive or tabling the proposal, they also did an impact assessment. And in this impact assessment, there are some quite interesting figures. And one of the investigations or analysis was they looked at how many people would actually benefit from a minimum wage of 60% of the median and 50% of the average. And we can see that overall, I mean, it's more than 25 million employees who would benefit from a minimum wage at that level. And that's, so we're talking, it's not peanuts, huh? It's quite a lot. I mean, it's obvious that in the larger countries like Germany, Spain, Poland, in absolute terms, we have most of the people that would benefit. But in relative terms, we can see that in Romania, Greece, more than a third of the employees would benefit from this directive. So it would have a substantial impact in raising the wage at the lower end of the wage spectrum in many countries. Another substantial impact, they also looked at the impact it would have on the gender pay gap. And since women are traditionally overrepresented amongst minimum wage earners, an increase in the minimum wage to those adequacy levels would obviously also lead to a reduction of the gender pay gap, and quite substantially in countries like Romania, Greece, Poland. In others, there would be less of an impact, but obviously it would have a big impact on the gender pay gap as well. So in that respect, it would also make a substantial contribution. Now, so the second key objective I mentioned, collective bargaining. Now in the threshold, in the directive, there is a certain threshold mentioned, and that is 70% of collective bargaining coverage. So every country that does not fulfill those the 70% threshold should put up or should formulate an action plan to actually increase the level of collective bargaining coverage to this 70%. The Parliament tried to raise this bar even to 80%. So let's see, I took it from the proposal, and there it's 70%. And even that would mean that the majority of countries would have to take some kind of measures to increase the collective bargaining coverage. And I think and that's why I put the colored ones to the top. And what we can clearly see is that in all those countries where we have more than 70% collective bargaining coverage, there is one way of state support. This can be the frequent use of the extension mechanism. These are the blue bars. This can be some kind of institutional help. And in Italy, it's from the constitution. In Austria, it's the chamber system that keeps up the coverage. And in Sweden and Denmark, it's the Ghent system, which obviously is also supported by the state. But that keeps up the union density figures, and that ensures a high coverage. So in all those countries, we have some kind of state support, and in all the others, this kind of support is lacking. So I think that's already an important pointer, that without some kind of state support, you will never reach the 70%. And that's why it's so important that the directive specifies that those countries that don't have 70% of coverage have to come up with an action plan of some kind or another to increase this coverage. And I don't go into detail with what's proposed, because I think the later speaker will do that. But it's just to show you, it's very important that we always look at these two objectives in common. It's the one is the increase of the minimum wage, and the other one is strengthening collective bargaining. And I think the key method, or the king's method, to establish high minimum wages is still collective bargaining. And that's why I think it's very important that the directive has this objective in there as well. Now, to conclude, the political importance of the directive, if we look at it from a broader picture, I think it's very important that we notice there is, I mean, in a paper I wrote with my dear colleague Torsten, from the WSI in Germany. We call it a paradigm shift. Maybe that's a bit too strong, but there has definitely been a change in the view of wages and collective bargaining. Because if we think back to 2008 and 2009 and the dealing with the Great Recession, there it was all about austerity and structural reforms, and that means freezing or even decreasing of minimum wages and decentralization of collective bargaining. And I think this changed, and the directive, the minimum wage directive, is one of the clearest examples of this change of view, because I think the minimum wage directive can be seen in as one element in a broader demand side oriented recovery strategy. And that's all about, we have to put workers in the position that they earn enough to drive the economy from a demand side view. And then I also think that this has to be seen from a social perspective, because I think the minimum wage directive also is the acknowledgement that we need social progress. Sorry if it's a bit loud, there is some mowing going on out there. Okay, now it's better. That social progress is key for the political stability of the European project, because I think all the austerity and the decentralization measures have led to a very Eurosceptical view. And it's an acknowledgement that we see Europe needs to do something good for the citizens, so that we have a more pro-European view. And I think that's an important part of the directive as well. And before the mowing gets even louder, I finish here. And if you want to read the paper I just mentioned with my colleague Torsten, it's in the Italian labor law e-journal, and there you can find what I just said written down in a bit more detail. Thank you very much for your attention.
Thank you, Torsten. Thanks very much. I think you touched upon very sensitive issues, particularly when you recall the two main objectives of this directive that are, of course, mirrored in Article 4 and 5 of the directive. Still, the third objective, so the reduction of minimum poverty, is yet to be addressed. At least that from my perspective. But it's nice that you mentioned your article in the Italian Labor Law Journal, because now I would like to give the floor to the director of the Italian Labor Law Journal, Emanuele Menegatti, a friend, professor of labor law in Bologna. I always keep with me your last edited book about the sources of labor law, and I look forward to get the book about decent work in the digital age. Emanuele is one of the most experts in Italy on minimum wages, so it's always a pleasure to have you, Emanuele. You have around 20 minutes. Thanks again for being there.
So thank you very much, Luca, for having me here, and also to Labor Law community. And thank both to Torsten and Luca for mentioning the Italian Labor Law Journal. So thank you very much. Okay, so what I'm going to do is to highlight the different views and the interest laying behind the proposal made by the Commission. And then I will try to point out where the compromise is emerging in the Commission proposal. Sorry, let me move to this. Okay, you can see the slide. Yeah. Okay, I'm using the same graph used by Torsten. The graph used by Torsten was more up to date. So, but the point is the same. Wage levels are very different, and so this is the first compromise between roughly east versus west and north, we can say. Of course, the gap is increasingly closing between the countries, as Torsten graph showed us. But perhaps it will take like decades to have the right gap among the European countries. A right gap is a gap able to exclude substandard wages, allowance, or social dumping. So the first idea of divergent interest is about the wage levels. A second difference is about the role of collective bargaining. Again, Torsten showed a graph which was similar, not exactly the same, but again, you see here that collective bargaining especially multi-level collective bargaining, is the main driver of wage adequacy in all the country. There's a demonstrated direct relationship between the collective bargaining coverage and the adequacy of wages. And as you can see here, the situation among EU member states is very, very different. And perhaps this is a consequence of the different attitude of governments and also social partners towards multi-employer collective bargaining. And some countries are just ignoring multi-employer collective bargaining. Some governments are also fighting it. And so perhaps one of the other compromise that the directive is aiming to find is to support collective bargaining, as already Torsten said. A third compromise is about the different wage setting mechanism we have in Europe. Most of the countries in Europe, as well as in the rest of the world, they set minimum wages by statutory law. In a minority of countries in Europe, minimum wages are set exclusively by collective bargaining, and that's the case of the Nordic countries plus Austria, Italy, and Cyprus. So in the countries where collective bargaining is the only players as for wage setting, it's the social partners and sometimes even the governments are strongly against the statutory minimum wage. And so one of the main concerns when the Commission start talking about the possible EU Act legislation on minimum wages was that they could be bound by the introduction of statutory minimum wage, which is not the case. Another compromise is not among member states here, but as among the concept of work of employee. The minimum wages are in most of the European legal system, if not all, targeted only to employees. That's I would say is, of course, a choice of member state. Sometimes is even consequence of competition law and also Article 101 of the Treaty on the Functioning of the European Union. Because we know competition law may work against the recognition of collective bargaining for self-employed. However, as I'm going to say, there's an undergoing trend by the European Court of Justice of expanding the scope of many employment and social protections beyond traditional employment towards all those work relations, those workers who are functionally and operationally dependent from one client or principal. Even the Commission itself is recently working on the guidelines about granting collective bargaining for solo self-employed. So perhaps as for the scope of application, there is another compromise between targeting it only to employees or expanding it towards solo self-employment. And again, the directive tells something else about that. The most important compromise, perhaps, is that about the EU competencies. As it's well known, the EU has broad competence in the social fields, and in Article 153, there's a long list of topics that can be dealt with by the European Union. But we know that the topic of pay is expressly excluded from the EU competence. So there's no room for a legislative measure passed by the European Union on the topic of wages. The reason for that exclusion is that of preserving member states' autonomy on a very sensitive field of their economic policies, that's to say wages, and also preserving the autonomy of the social partners. So member states decided to take this out from the EU competence. And again, a compromise, also Torsten told us something about that compromise, is necessary in order to make EU binding legislation. which legal instruments? During the consultations before the Commission proposal, we assisted to these. We had this debate between different views between the European Trade Union Confederation and the Employers Association organization. The ETUI claimed for an ambitious framework directive, while the employers, they wanted just a recommendation within the EU semester. So they agreed on the necessity to have something at EU level on minimum wages, but the legal instruments, the instruments to be used are rather different. So which compromise has made the European Commission in order to make this proposal? I'm referring to the original version of the EU Commission, not to what is going on during the trialogue. And looking at the original provision, the first compromise was that of addressing a different set of obligations to countries with a statutory minimum wage and to countries without a statutory minimum wage. So you see, country with a statutory minimum wage, they have a full set of obligations, including the criteria for setting minimum wages, the reference values for assessing minimum wages, then regular and timely update. I'm not going to read all the list. The country without a statutory minimum wage, so where wages are set mostly only by collective bargaining, you see the obligation are limited. So there's nothing, of course, about the criteria for setting the minimum wages, but just about the support to collective bargaining, plus other horizontal provisions dedicated to all the EU member states. And as already has been said, there is no obligation for member state to introduce neither a statutory minimum wage nor an extension mechanism. So that's the first compromise. The country without a statutory minimum wage, they don't have to introduce it, and they don't have also to make use of an extension mechanism. The second compromise is about the scope of application. I already mentioned before the possibility, the options. It could be targeted only to employees, as according to the national concept of employees, or the directive could have a broader scope of application. Here, the Commission made use of the same, let me say, ambiguous formula that has already been used for 2019 directives, the one on predictable and transparent working condition, and the one on work-life balance, which is again a compromise emerged from the trilogue for that directives. And as you can see, the scope of application is for workers in the union who have an employment contract or employment relationship according to national law, but with consideration to the case law of the European Court of Justice. Why that? Because of course, the national concept of employees, as I was saying before, is much narrower than the concept of worker provided by the European Court of Justice for some pieces of EU legislation. So the idea is that basically the reference to the concept of worker provided by the European Court of Justice is a way for pushing let's say, the scope of application of the directive, and so of minimum wages beyond the boundaries of traditional employment, which is that defined by national concept of employees. As for the legal basis, as I said, perhaps the most difficult legal issues that the Commission had to face when proposing such a directive. The European Court of Justice jurisprudence made rather clear that the pay exception, the several also, cannot be extended to any question involving any sort of link with pay. Otherwise, much of the EU competencies in the field, in the social field, would be deprived of their substance. For example, you see equal pay for equal work between men and women. Of course, when the EU treaty, the Treaty on the Function of the European Union states that is not interfering with the topic of wages, but it's just telling you, you can set your wages as you like, but you need to grant the same wages for men and women. if they do the same job or similar jobs. Many directives are including the principle of equal pay for equal work. Basically, an indirect interference in the field of pay is admitted. What is not admitted is, you see, the import case is the EU setting the equivalence of all or some of the constituent parts of pay, or the level of wages in the member states, or even setting a common EU minimum wage, which is not what the directive is doing. So direct interference on the level of wages in the member states is not admitted because of the lack of competence. The Commission in the recitals of the directive has been rather clear in, say, relaxing the member states. We are not harmonizing the level of minimum wage. We are not establishing the uniform mechanism. You are not obliged to introduce a statutory minimum wage. So basically, we are not interfering directly with wage setting in your countries. What the proposal made by the Commission is doing, as you can see, this is taken from the directive, is asking member states to introduce these clear and stable criteria for minimum wage setting, considering a set of parameters which normally are considered by many governments when they set the minimum wages. So introduce these criteria. Here is a list of possible criteria. Introduce a reference value. The 50–60% of median average wage is included only in the recitals of the directive, so is not binding for member states. Update them, involve social partners or also an independent body. So basically, the directive includes here guidelines for member states in wage setting, without any direct interference in the way they set the wages and on the level of the wages. Perhaps the only interference is the provision that is asking member states to eliminate exemption and variation referred to minimum wages. They should evaluate in order to maintain them if they are non-discriminatory, if they are proportionate, justified, and so on. Perhaps in that specific field, this specific topic, there could be a kind of interference of the directive. For example, Germany, there is an exception from the minimum wage for long-term unemployed people. And that's just a theoretical, argument. I'm not saying that the European Court of Justice, the Commission, is telling Germany that they should remove this exception. But there is this exception for long-term unemployed people. Maybe the Commission or the Court of Justice can consider this exception as discriminatory or disproportionate. I don't know if they're going to do that. But in that case, it would account as in an interference in wage setting, of course. That's at least my opinion. The last point, promotion of collective bargaining, then I'm concluding. As already has been said, member states should try to increase coverage of collective bargaining, as you can see, promoting the capacity of social partners to engage in multi-employer collective bargaining, and to start constructive, meaningful, and informed negotiation, and so on. A more, say, concrete obligation is when the directive tells member state that if the coverage of collective bargaining is lower than 70%, perhaps now has been increased to 80% in the trilogue, they should provide a kind of action plan in order to boost the coverage of collective bargaining. As for this action plan, I try to speculate on what member states can do to increase the coverage of collective bargaining. Starting from the assumption that collective bargaining is legally feasible in all member states because of EU law and international obligation of member states, the next step is a kind of legislative promotion of collective bargaining. And so you see here, capacity building and training could be provided by member states. strengthening the access to workplaces, so guarantees for unionists to access the workplace, and recognition of some rights that can permit unions to enter the work premises and develop unionization and collective bargaining. Another option can be incentives or benefits related to the application of collective agreements. For example, in Italy, we have a kind of discount on social security contributions in some pieces of legislation if you apply the collective agreements. So some benefits related to the application of collective agreements. Or the next step, the last step, is by imposing a kind of instruments that can expand the scope of application of collective agreements. The directive is not telling that member states, so there's no, as I said, obligation to introduce an extension mechanism, no obligation to introduce, for example, a mandatory engagement in wage bargaining and so on. What perhaps the directive is aiming to is to the legislative promotion. So the member states should do something in order to promote collective bargaining. To conclude, the product made by the EU Commission is a kind of very light directive, which is very similar to a set of recommendations. Perhaps that was the only compromise, I mean, not only politically, but also the only possible compromise in the light of the EU competencies. So at the end of the day, this is what we are going to have if the directive is passed, as perhaps is. Thank you very much for your attention, and sorry if I went too long.
Thanks very much to you, Emanuele. No, you did not. You did perfectly. You respected perfectly the timing. I think it was very important what you said about the coverage, the equation between coverage and adequacy, which is probably one of the most contentious points, and as well as what you said on the competence conundrum. And here we just stay and wait and see what happens if one or more member states start an action for annulment before the Court of Justice, and there we will see what happens here in Luxembourg. But it's very interesting, your speculation about the action plan, because since this is a main obligation on the shoulders of the member states, it would be interesting to understand what is expected by the Commission in this action plan and how the member states will react to this, which seems to be a procedural obligation. Is it a light directive? Well, probably you're right. Let's hope it's not watered down in the trilogue next week. So thanks very much, Emanuele, for your insights. Now I will give the floor to Anki HARTZÉN. She's a senior lecturer at the University of Lund. She has worked a lot on minimum wages, on inward poverty in Europe, and particularly inward poverty in Sweden. And she just edited a very nice book together with other two authors on solidarity and the limits of social Europe. So Anki, the floor is yours. You will give us a Swedish perspective. Thanks very much.
Thank you, Luca, for that nice introduction. Yes, my intention today is to provide kind of the Swedish view on the minimum wage directive. And I should probably point out that my personal view is not exactly representative of the general perception of the minimum wage directive in Sweden. So what I will say here will be a kind of a compromise to try to provide the idea and perception from the Swedish perspective, but also highlight from my point of view what the what is at stake if we look at the actual legal consequences here. So to do this, I will provide first a brief introduction to the Swedish model with the wage setting through collective bargaining structures, a specific issue of concern for Swedish social partners, which are so-called numberless collective agreements. Also a brief introduction to what I call the blind spots of the Swedish model. I will then go through the main consequences that the EU directive, as formed in the proposal from the Commission, would probably bring, and give some concluding remarks. So if we start with the Swedish model in a very short, brief term, it's a structure or a system where we have self-regulation as the basis for labor law relations and labor market relations. So basically, legislation has been introduced by the governments or the legislator when social partners have not managed to agree and there has been a need to intervene in order to retain labor market peace. And also recently, actually, at request from the social partners together with the ongoing changes to the Employment Protection Act, for example. We have a system where the legislation that is introduced often is possible for the social partners to deviate from through collective agreements. And that would be also imperious for the workers. So there is a vast scope of action for the social partners, even though there is legislation. When it comes to EU directives and EU labor law implemented in Sweden, there is, however, always a bottom line that cannot be undercut in order to assure that the demands from EU law are respected also in collective agreements. Also worth noting is that we have roughly a 90% collective agreement coverage rate in Sweden, but there are no modes for extending collective agreements and making them general applicable. So we do not have erga omnes effects of collective agreements in Sweden in that sense. So wage setting model in Sweden, though, well, it builds on wage setting through collective agreements. So we have no legislation on wages. The systems for setting wages varies between different sectors. So there are collective agreements where lowest wages are defined. There are collective agreements where entry-level wages are defined. There are occupational tariffs. There are a number of different structures in different sectors and how the lowest or minimum wage is set. It is also possible for local parties, so the actual employer and the local trade union, to agree on adjustments to the wages set in the sectoral level collective agreement. It is not possible to undercut the sectoral level wages, though. The sectoral level is also the level where we have the annual wage adjustments agreed upon. And these are normally negotiated and agreed on, for example, for 2 or 3 years at a time. And the praxis on the labor market is that the exporting industry agreement sets a kind of a benchmark that the other sectors are to respect. So, for example, public employed workers within the health and care sector would not, unless something very unexpected was to occur, they would not be able to sort of demand higher wage adjustments than the exporting industry employees are getting. The model and the system has generated real wage increases over the past decades and an economic stability. So the social partners have taken responsibility to foster also wage moderation in order not to induce inflation and so on. And this is as such a model that there is a great interest within Sweden to protect and assure a fruitful future for. Within this model, we also have seen some developments lately with in the more recent years with so-called numberless agreements. And these are collective agreements where wages are not indicated in terms of any specified numbers at all. Instead, these agreements are intended to assure individualized wages, and that what is to count for wage setting is competence, merit, and performance of the individual employee. And this is assured then by a process for wage setting that is regulated in these collective agreements. This process also includes requirements for employers to define clear criteria for how wages are set and how wages are adjusted and so on. It also involves a guarantee that the trade union may influence and control parts of the wage setting process to assure that there is still a dialogue between the employer and the trade union. It is also important to point out that this is not a kind of agreement that would occur in any sector or in any workplace. It's mainly applicable for academically trained professionals who also have quite high wages. But this is something that the social partners like to highlight as an issue in relation to the minimum wage directive, and a concern because this is considered part of the Swedish model, and as such by the social partners there's a fear that this could be questioned. If we continue with the Swedish model, and I just give a few words on the so-called blind spot of the Swedish model. As I said, we have a 90% collective agreement coverage, which is 100% in the public sector and a bit lower in the private sector. But we have only about 70% unionization rate. So the collective agreement coverage rate is generated due to employers in Sweden being more inclined to organize than the workers actually are. We also have an issue with low collective agreement coverage in some sectors. For example, hotel and restaurant sector has a generally lower collective agreement coverage, and it's also a sector where the rate of unionization is much lower than the 70%. And then we have the issue with the Swedish model, and this is probably the main concern of the social partners in Sweden, and that's the fact that if there is no collective agreement in the workplace, there is no minimum wage regulation either. And no way to guarantee it. So even though there is praxis from the labor court through which unfair or unreasonable wages could be questioned, and where the wage levels from collective agreements would be considered in the reasoning of the court in such a case. This is a kind of a complicated process that is not really considered guaranteeing a secure protection for minimum wages if you do not have a collective agreement in the workplace. So let me move on now to how I see the EU directive consequences for Sweden. So first of all, well, the articles concerning statutory minimum wages will of course not apply to Sweden. So the wage setting model through collective bargaining, through collective agreements will be maintained. If we look at the other articles then, we look at Article 4 on the promotion of collective bargaining. The consequences of this article would of course depend a bit on the final rate of collective bargaining coverage set in the directive. But in general, it should not be a problem for Sweden, as long as the definitions in Article 3 are not changed drastically towards what the Commission proposal was giving. The current definition of the proposed directive concerning collective bargaining coverage refer to the national level. And as long as that will be the case and there will be no issues relating to different sectors and so on, it would not be a problem for Sweden. But here we have an issue from the Swedish actors with a fear that the definition of collective bargaining coverage could end up being interpreted in relation to various sectors and so on. And then there would be issues in Sweden as well. So what can be said in relation to this, nevertheless, is that the social partners and the Swedish current and coming governments will need to act strategically to assure that current collective bargaining coverage rates are maintained, and that we do not see initiatives that would sort of undermine willingness to unionize or willingness for employers to maintain their memberships in employers' organizations. So, another article that could provide some consequences for Sweden is actually the Article 10 on monitoring and data collection. The reason this has stirred some worry in Sweden is that collective agreements in Sweden have traditionally been viewed as the property of the parties to the agreement. So collective agreements are not distributed to each and every one, but has been kept for the parties to the agreements and their members. This is starting to sort of be a bit blurred. One of the largest white-collar trade unions in Sweden, which is actually called Unionen, the union, they have actually started to publish all their collective agreements on their webpage. So this is starting to sort of blur out and might not be as problematic anymore. And what we would see, on the other hand, due to these requirements, is that we would have actually improved wage statistics in Sweden. So for those doing research on wage levels and wages, it would be positive. If we look then at Article 11 on the right to redress, the current formulation in the proposal is framed as a form of systemic protection rather than an individual right to redress. It's to cover those that are covered by this minimum wage protection offered by the system applied in the country. So as long as that is not changed in any terms, we will not see too much of an issue in Sweden. So if we aim to sum up now, what is there a need for concern? Well, I have basically said most of this already, that it depends a bit on the final version of the directive being adopted. Will we see changes or adjustments in Article 3 on definitions? This could bear consequences. The proposed changes from the European Parliament were a bit worrying in this regard, requiring, for example, to have a formulation including collective agreements as an instrument where wages are defined. And the levels of collective bargaining covering rates in Article 4 could also pose some concern, as well as potential changes to Article 11 on the right to redress, if that was supposed to, would be framed more as an individual right, which I doubt, however, because it would go against the idea of the directive to protect tertiary systems of setting fair and adequate wages. So what is the fuss about then? Well, I think the main issue is the tradition and technique for wage setting in Sweden, that the Swedish actors are so keen on protecting and assuring that it will be maintained, that it will be the social partners that are in charge of setting minimum wages without meddling from political levels. So that is like also from Swedish actors, what is highlighted mainly that we want to keep the system as we have it, and the directive opens for a risk of further political involvement that we do not wish to open the sort of Pandora's box. But we also have the Laval trauma in Sweden. The Laval case and the consequences it brought for the perception of the right to industrial action in Sweden, and the capacity of trade unions to assure decent working conditions for workers in Sweden, regardless of whether they are employed by a Swedish employer or sent from abroad to work temporarily in Sweden. It has generated a great distrust in EU level labor law legislation, period. Anything that comes within the labor law sphere from the EU will generate an opposition in Sweden, most likely due to the sort of fear that we will see another instance of court judgments causing similar effects or as strong effects for the Swedish model as the Laval case did. So I think from my point of view, that is the main issue, and that distrust is something that the EU and Sweden will need to work on in other issues as well. So that was what I wanted to say. So I thank you for your attention.
Thanks very much, Anki. I think you gave us a very, very interesting insight about, particularly when you discuss about the blind spots of the legal system, which is in place in Sweden, and what you said at the very last slide with the challenges and the many legal questions that are raised by Article 11, and also would say by, if you allow me, also by Article 1.3, where the directive says nothing is in this directive will become or must be interpreted as an obstacle for the member states' legal systems to build their own industrial relation systems. It's definitely the case that this directive will have a way or another some impact on the systems of industrial relations. We will see how far this will go. And it's also very interesting what you said about the fear of the Court of Justice creativity, particularly when it comes to the interpretation of some of these articles. I have my Article 11 again. So thanks very much. We will maybe come back to some points in the debate. Now let me give the floor to Lise Lotte from the Danish Trade Union Confederation. She's responsible for the EU and international policy developments. So Lise, thanks very much for being here. You have approximately 20 minutes.
You're welcome. And I think my slide should be on the screen. Yes?
Yes, they are.
And also thank you very much for the invitation. And I think the timing is very interesting. As we know, the last trilogue will take place on the 6th of June, and we have EBSCO later on that month. So let's see what the trilogue will end up with. As you said, I'm not from academia. I am from FH. First of all, I thought we'd just have a short look on Denmark, because we are so many different countries here, and I think we are quite a small country. As you can see, we are less than 6 million people. We have a very low unemployment rate at the moment. I think it equals also the situation in other member states. And actually, we have a very well functioning labor market. FH represents 1.3 members, and we are representing people with low skills to vocational training education and medium higher education, teachers, nurses, social workers. So we cover the public sector, large part of the public sector, and the private sector. And then in relation to, because I will not repeat, we just heard from Sweden, but there are so many similarities between the Danish and the Swedish labor market. But so I will not, I'll try not to repeat what Anki just said, but I think it's very important to understand what's the fuss about this in relation to the Danish view on the directive. And just to understand the characteristics of the Danish labor market, we have this constitution, the September settlement from 1899. If you come to Copenhagen, you can drop by and actually see it. So it's almost 125 years ago that we agreed that employers have the right to allocate work. It constitutes a framework for settling labor market disputes. It recognizes the workers' right to organize themselves. And last but not least, it regulates wage and working conditions in collective agreements without the interference from government. And this is actually still the settlement that lays the framework for collective agreements today. Of course, we have the responsibility to adjust our model so it keeps pace with changes in society and remain fit for the future. But we're quite proud of the way we are organizing ourselves without the interference from government, and so is government. So that's just the outset of a way of looking at the proposal. The Danish social partners then play this key role in coordinating collective bargaining, the conflict resolution. We're also doing lobbying, and we have services for our members. Looking at the collective bargaining system, every 2-3 years we have the framework agreement at branch level. Next year we will have the negotiations in the private sector, and the private sector always comes before the public sector. So the public sector will sort of go behind the private sector to ensure competitiveness. We are also responsible for conflict resolution, and this is also something, looking at the directive, that we are quite skeptical. We're very eager to ensure that the directive will not interfere with the way that we do conflict resolution in Denmark. But what's most interesting here is that most collective agreements only set the minimum wage. The actual wage negotiations takes place at company level, and this is where this second level, the individual workplace, comes into focus as perhaps the most important level at all. So the fact that this, as you see the company level every year, there you have the actual negotiation, which is of course very flexible and local. So the main characteristics, just as in Sweden, we have a very high level of unionization. We have a very flexible labor market. It's very easy to hire and fire. We have a very high level of security. And here I think it's important to mention that our welfare and social benefit system are mainly financed by income taxes and other taxes, creating a rather large redistribution. So the welfare and social benefits are not really linked to the employer. So that also creates a huge flexibility and movement on the labor market. People are not afraid of changing jobs or going without job for a while, because they can get unemployment benefits, and the whole social system, social security system, is not linked to the employer. So that's another important ingredient, and also important to think about when we compare wages, because social benefits and insurance and so forth is not part of our wage. So looking at the wage level in Denmark and compared to Europe, you can see that because of the collective bargaining system, we have a rather compressed wage structure. Well, actually in the Nordic countries, blue-collar workers with the low pay, the low levels and short educations, they actually have a rather high wage level compared to other member states. And this is linked to the historical wage setting through collective agreements and the large redistribution of in our welfare system. Almost 1/3 of the workforce every year changes jobs in Denmark. This is how, when you talk to someone from Belgium, or people get very surprised that people dare to do this. So looking at the results, we've seen similar graphs in the previous presentations. We have a very low share of long-term unemployment, a very low unemployment rate, and quite a high salary. So what is really our challenge with the directive? First of all, we have reiterated this many times. We really don't think there is a legal basis for the Commission. Now we have the Council Legal Service opinion and the European Parliament as well, but we believe that the exemption of wage setting in Article 153(5), we believe it's a slippery slope to make this framework directive, because if it doesn't really influence wage setting, why do we then adopt it? So it's very principal legal opinion, and we've had, of course, Danish legal professors making long notes on this issue and arguing. I will not tire you with the arguments, and we have also forwarded them to the Council Legal Service and the Commission 1.5 years ago when the directive was presented. So we still don't believe, that's our first argument. We don't believe in the legal base, and secondly, we are really afraid that it will become a slippery slope. Now we see that just like the social pillar, it was supposed to be in Göteborg in 2017 when it was adopted. Everybody agreed that this is just political guidelines, it's not legal binding. And then we've seen directives coming one after the other. So we really support a strong upward convergence in Europe and a just and fair transition into the future. But taking measures where you actually interfere with the very national labor market models, that we are very much against, for the reasons I have explained and the historical reasons. So what will happen? I mean, the proposal that's negotiated at the moment, as I understand it, the Parliament has suggested 80% in relation to the rate, organization rate in Article 4. And as I showed you before, I think actually our organization rate is depends on how you actually calculated it, but it's very close to that. We will start having a system where we will have to make an action plan to strengthen the membership of people's membership of unions. And doing that, we have the same problem as in Sweden, actually, because our collective agreements are not distributed. We don't have one-stop shop where we can look at how the Danish labor market is organized, the number of collective agreements. It does not exist because it's something, as I showed you before, which happens very much at local level. And then, of course, the overall frameworks are decided at a higher level. So it will be extremely difficult to create that overview and costly. That's a second thing, but we will need to do this if we have to justify our unionization rate and how we we actually plan to strengthen the unionization. So that would be completely new to us and the way we are organized at our labor market. So we really want to keep our system, and for us, just like Antti said, this is a bit Pandora's box or slippery slope, because we haven't discussed much at this seminar, but we also have the European Court of Justice and the way they are looking at articles and sort of integration that is sort of the object of the European Treaty. It's very hard to foresee how a possible, perhaps an individual worker's complaint, what will happen. We are very much afraid that this will end up giving actually workers individual rights. That's another aspect. Yes, so I think we've been fighting against this. You know that it's no secret, but it's really not to be solidaric. It's really to keep our own system, which is very well functioning, and not get into a system where we have to justify every year how we are regulating our labor market, and we've been doing this the past 125 years. We really believe that capacity building is the way forward, and personally, I think there's one thing we never discussed when we discussed this framework directive is, where's the money? How, I mean, if some of the countries who have very low paid and low skilled workers, and then you have this framework directive, will it make any difference? Because you still have a BNP and a medium, which is very low. So, and if the system doesn't have the possibility of remuneration or strengthening the wage levels, I mean, it's hard for me to see how this will push in the very ambitious way that Ursula von der Leyen has promised. She doesn't have the toolbox to do what she promised, not with this directive. But we are following it closely, and I think it'll be very interesting to see how this ends up. And if it ends up with a framework directive, we will take it from there. Thank you.
Thanks very much, Lise. It was a very interesting point of view, and that was exactly what we wanted, what we expected from your intervention. I think it's very much interesting to see what is another point of view on this directive. We heard enthusiastic reactions, but we also heard so far very critical reactions like yours. I think you mentioned important documents. You mentioned the European Pillar of Social Rights, which you expected to be a political declaration and with a limited impact on EU labor law, which in fact was not. And here we could draw a parallel with the 1989 Charter of Fundamental Rights of Work, which was also a political declaration, but also gave rise to a number of directives and self-standing initiatives from the European Commission. So I think that you very aptly described the framework and the point of view from Denmark. And probably in a word, you defended the collective autonomy typical of the Danish model, which is critically assessed sometimes in Brussels and also in Luxembourg by the European Court of Justice. So thanks very much again. We may get back to you in the debate. Let me now give the floor to our last speaker, Professor Antonio Lofaro from the University of Catania. He's Professor of Labor Law in Catania. He's one of the experts on EU social dialogue, and he also teaches at Luis University in Rome. Antonio followed the directive proposal since its inception, so since the very beginning. And so we are very happy to have you here, Antonio, and we are curious to see what you have to say now. Thanks very much. Okay, Antonio, you can just turn on your microphone and we can see your slide.
Thank you, Luca. Can you hear me now? Can you see the slides?
Yes, perfectly.
So, as the previous two speakers of this, let's say, second session of the webinar, my presentation too will not deal with an analysis of the directive per se, but rather with a national point of view of it. And I guess it is no surprise that after Sweden and Denmark, also this third national perspective comes from a country with no minimum wage, or at least with no statutory minimum wage. And this leads me to start from some general remarks. First of all, with this proposal, it is confirmed, if anywhere needed, that there could be life for a minimum wage policy beyond a legislative minimum wage. But this is quite obvious and not that new. What maybe is a little bit more surprising is that the major part of the debate has been concentrating up till now upon something which probably was not the original primary goal of the directive. I mean, the primary goal of the directive was adequacy. And the directive itself concentrates the provision on adequacy in Chapter 2, addressed to statutory minimum wage countries only. So it is quite remarkable that a directive basically meant to be an intervention on statutory minimum wage ends up in being mainly discussed by countries where wages are left to collective autonomy of the social partner. And this is already something to be noted. However, not all member states without statutory minimum wage are the same. And if it is true that Italy share with Denmark and Sweden the condition of being a contractual country, this is all they have in common. Not only Italy does not have the same welfare system contributing to secure decent living wages, but also, and most of all, Italy certainly does not share with the Nordic countries and Austria, I would say, a smoothly functioning and efficient system of industrial relations. So this is why the Italian attitude in front of the proposal is probably not the same as in the rest of the contractual countries. When it comes to the functioning of a minimum wage model built on collective bargaining, in Italy there is not much to be defended or preserved for the simple reason that the Italian industrial relations system does not work as well as the Swedish and Danish one. And this is why in Italy the directive tend to be seen not as, let's say, the paper tiger that the Nordic countries would pretend it to be in order to be left untouched, but rather as an occasion to change something, even if it is not at all clear what has to be changed and how. The point is whether or not the directive, the future directive, will be capable of supporting or promoting or at least triggering this much needed process of change. Now, even if I agree with many observers that the proposal does have a strong positive political value, because a Commission initiative on living wages through collective bargaining would have been simply unthinkable, let's say 10 years ago. Well, having said that, it still remains to be seen whether this text could be a real game changer or not, especially in that part of it where the political approach of the Commission has been, so to say, quite attentive to national tradition. There is no doubt, Emanuele has said that due to the political compromise on which it is built, this is a very prudent and cautious directive, a gentle directive, we could say. And the question is it so gentle and careful not to disturb national system up to the point of being unambitious and finally ineffective in pursuing its substantive goal? So could we say that its regard for national tradition, which is a point of strength for Nordic countries wishing to be left undisturbed, at the same time could be a point of weakness when seen from the perspective of countries needing to improve their minimum wage system? So this is a premise in order to describe what I will try to do now. Not a mere internal discussion of the Italian case, which would be inappropriate, but rather a reading of the proposal from an Italian perspective in order to understand if and how the future directive will be capable of moving something. In doing so, I wish here to inform that this kind of analysis is part of a bigger national research project, which I'm happy to be part to, which has been funded by the Italian Ministry of Education and is run by the University of Bari, Siena, Modena, and Catania, and led by our colleague and friend Vincenzo Bauer. So this research project has just started. Maybe in 2 years' time, we will organize a webinar to present the results. But for the time being, we just began to identify some issue. And this is basically what I will try to do today in the form of offering you 5 points, which I just put on the table in the form of question, the answer of which we still do not know. First point, coverage. We know that basing on empirical data showing direct proportionality between collective bargaining coverage and minimum wage standards, the proposal is built upon the assumption that when it comes to non-statutory system, wages are supposed to be adequate insofar as coverage is at least 70 or 80%, we will see on the 6th of June. Now, according to many sources, ETUI, but also Eurofond, ILO, OECD, Italy is credited with a rather high level of coverage. And therefore, it seems like there is nothing to be done when implementing the future directive, at least no action plan to further promote collective bargaining according to Article 4, paragraph 2. So is really everything clear? I would say no, and let me just list some issues which are currently debated by the Italian observer and which require a more careful interpretation of the directive. So this is, or this could be a slide used by the Commission, which shows indeed that more or less high salaries and high coverage go more or less hand in hand. But is this an absolute truth? When we look at the slides, we may see that there could be the case of high coverage countries with low wages. For instance, Slovenia and Portugal are above 70%, and still their hourly gross wage is not that high. But Slovenia and Portugal have a statutory minimum wage system. So the problem is what about countries where coverage is high, wages are low, and no statutory system exists? I think that the directive does not offer any help in this case. And here, of course, I touch the problem of adequacy, which I think in the directive is somehow overlooked, and I will deal with that in a minute. But the second critical issues of coverage rates as a key point may be trivial, but the point is, how is coverage to be measured? Is the Italian 80% of coverage rate realistic? I do not want to go into detail, of course, but it is not at all an easy task. And just think that in that research project, which I was talking about before, we are trying to conclude a series of agreements with institutional actors, the Ministry of Labor, the National Social Security Institute, the National Council for Economic and Labor, because each of these actors have its own method to calculate coverage rate, and they do not really produce coherent results. And this may lead me to the second point. Which collective agreement must be taken into consideration when calculating the coverage rate? Any agreement or only qualified agreement signed by representative unions? I must spend just a few minutes to inform say non-Italian participants about the very peculiar situation characterizing the national Italian industrial relations system. Italy is characterized by two factors, in short, giving rise together to a sort of regulatory mess. The first is that there is no erga omnes effect. And the second is a full recognition of trade union pluralism, both on the employer and on the employee side. So this gives rise to an extreme fragmentation of collective representation, which has produced in the last, let's say, 5 years, a true explosion of the number of collective national industry agreements, more than 900 at the moment, 42 only in the mechanical sector. So why do I say that? Because this is a big issue for coverage and for adequacy too. It is a big issue, a big problem for coverage, because the proposal does not make any difference between qualified and not qualified agreements when calculating the coverage rate. Qualified meaning agreement signed by representative unions. And it is a problem also for adequacy because, well, it is true that agreements signed by representative unions are applied to a vast majority of workers. That's a point. But it is also true that the sheer presence of unqualified agreement opened the way to what is called contractual dumping, with undertakings having the possibility to leave major employers' association to play as free riders or to associate to some minor employer association securing lower wages. So to make a very long story short, the lack of clear rules on union representation, which is the everlasting Italian anomaly, makes the trust of the proposal towards collective bargaining as a valuable means to secure adequate wages maybe too optimistic as Italy is concerned. Also because, and this is my third point concerning adequacy, it seems that both the Parliament and the Council have amended the original version by extending the notion of collective bargaining to be considered when applying the directive. In the slide, you see the original text and the slight different version. And by saying in particular, it seems that the agreement to be considered when applying the directive are not only national or industry or cross industry agreement, but also plant level agreement. At least this is how I read this quite worrying amendment which comes out in the both Parliament and Council version of the text. So as an intermediate conclusion, these first 3 points I raise, I would say that coverage, which is the sole and only criterion evoked in the proposal concerning the situation of non-statutory system, far from being a solution, could be rather a problem, because it is difficult to calculate, because it includes non-representative agreements, and because perhaps it includes also plant level agreements. So the weakness of coverage as the sole criterion to assess the capacity of non-statutory system to secure the substantive goal of the directive brings me to the 4th point, adequacy of wages. We know that reference to the double quantitative parameters, 60% of median wage and 50% of average wage, has been moved by the Parliament from the considerandum to the text of Article 5, even if a similar amendment is not present in the Council version. We will see in the trilogue. So is this enough? Is this moved from the considerandum to the text enough to give these 2 quantitative parameters a more hard value? Probably not, for a variety of reasons. Because these parameters are not binding, even if they are within the text of Article 5 now. Because they could be not enough. At least this is what the European Council of a Committee of Social Rights has said in a case concerning Greece in 2014, because they only refer to the system, the statutory system of wage setting, even if I have to say that there are positions in the debate claiming that the quantitative parameters of adequacy could also be referred to non-statutory country by virtues of Article 1 of the proposal, which refers horizontally to the goal of adequate level of minimum wages. And finally, but this is something to be further investigated, the 60%, the CAT index, could be very difficult to be applied to non-statutory system insofar as the variety of contractual standards between and within sectors might make it difficult to calculate. So to conclude on adequacy in non-statutory high coverage countries as Italy, it could also be interesting for you to know that in recent times, something new has happened in Italian courts, whereas in the past, judges have always considered that collective wages are by definition fair wages, coherent with the constitutional standard of, say, just remuneration. In recent time, Italian court has begun to say that even wages contained in collective agreement concluded by representative unions may not respect the constitutional fairness insofar as they go below the poverty line. And this is one of those results of the contractual dumping I was talking about before. So to conclude on the point of adequacy, it's really, or it's quite hard to imagine how a contractual model of wage setting could attain the goal of the directive without any more precise reference to adequacy. And this is how I arrived to my fifth and last point. Please, Luca, tell me whether I have 5 minutes left.
Yes, you do.
My fifth point, indeed, I could call it the mother of all problems in the wake of the directive future adoption, at least as far as the Italian debate is concerned. The problem is, shall Italy finally leave its fully contractual model of wage setting to adopt some form of minimum wage legislation, and shall the directive have a role in it? Well, this is a question that, say, even Nostradamus could not be capable to answer, because the academic and social and political and union debate on this topic is currently quite hot. One thing is, I guess, however, possible to be said. Whereas for Nordic countries and Austria, abandoning the contractual model is something that probably does not even cross their mind. In Italy, as I said at the beginning, there is nothing to be proudly defended, and there is therefore a sort of general consensus about the introduction of some sort of legislative intervention, even if there is no agreement on the form of that intervention. The only thing that I guess could be said is that legislation will certainly not substitute collective agreements, but rather have a complementary role supporting their effectiveness as sources of adequate wages. How could be that? Well, there are different proposals. I just want to mention some. Identifying sectoral minimum wages on the basis of the minimum wage identified by qualified collective agreement. And in this case, legislation would intervene only in a subsidiary way to fix an hourly gross wage of €9 to be applied only if and insofar as the agreement stay below that level. Then there are other proposals quite similar, saying that minimum legislation, a minimum wage is the minimum wage provided by collective agreement without any minimum threshold to be secured. Other proposals say that a legislative intervention should concentrate only in sectors which are not covered by collective agreements. And last but not least, there is quite interesting proposals, just academic proposal, saying that legislation, on the contrary, should fix a rather high level of wage, let's say 15 or 16 euro per hour, but then leaving collective bargaining the possibility to derogate in pay use. Why that? It's quite strange, a reverse of the first proposal. Well, the aim of this proposal is that of stimulating employers in engaging in collective bargaining. Because if employers know that without collective bargaining, they would pay a very high legislative wage, they would be induced to go to the negotiating table. So in this way, one of the classical objections to legislative intervention in wage setting, which is the disincentive of collective bargaining, would be avoided. Now, to conclude, this is not the occasion to go into detail about Italian future development. What could be interesting from an EU perspective, EU law perspective, is whether or not a subsidiary legislative intervention extending the application of collective bargaining wages would transform a national model from being contractual to being a statutory country, with the consequence to make Chapter 2 of the directive applicable. Now, there is various opinions about that. I would just note that, again, in the Parliament and Council amending processes, the answer to this doubt has been given, and we could say that, as you may see in the slide, that the answer is no. A complementary legislative intervention on the result of collective agreement will not make that model a statutory model within the meaning of the directive. So I just concentrate on the collective bargaining issue because I thought it was appropriate within the perspective of our Swedish, Danish, Italian session. But of course, there would be other important issues to be dealt with. I just want to mention and conclude the autonomous worker inclusion or not inclusion and the public procurement provision, which would be extremely relevant to the Italian case. Thank you.
Thanks, Antonio. Thanks very much for this incredibly interesting analysis on well, stemming from the Italian system, but then extending to the flaws of the current directive proposal. I think I fully agree with you on the binary divide between coverage and adequacy. The way they interact one another is far from being clear. And also, I fully agree on the fact that if we don't distinguish the quality of collective agreements, it would be almost impossible to understand whether the coverage is a good or a bad news for the labor market as a whole, and particularly for the most vulnerable workers in the labor market. So thanks very much. Now, we still have around 15 minutes for the debate. I see we have distinguished attendees in the room. So I would say that the floor is open for any question that you might have for our speakers who are still there and open to answer your questions. I think that their presentation so far raised an incredibly important amount of questions. Some of them are still left unresolved. So in case you want to ask a question, please feel free to turn on your camera and or your mic, or to write in the chat, and I will try to moderate the question. Is there any question from the audience? If not, yeah, yes, there's a hand. Oh, Marzia Barbera, she's the president of the labor law community. So Marzia, thanks for being here.
Hi, good afternoon, everyone. So thank you for giving us this very interesting account of what's going on the discussion, about the discussion on the proposal. And we have seen here both optimistic views and skeptical views. And it's interesting also to register different aptitude by the speakers. Let's say that from one hand, we have this desire to be left alone, which has been described mainly by the Scandinavian speakers. And on the other hand, there's an opinion like Antonio's FARO opinion, which says, well, the Commission initiative has to be so respectful of the national experience as to risk to become ineffective. So we have a different aptitude towards the same proposal. I have here two questions for the speakers. First of all, I would like to ask both to Lise and to Anki, if they could elaborate a little bit more why the definition of collective agreement and the right to redress are seen as reason for concern by the social partners. And the other question is more general. It seems to me that there are two aptitudes towards the question of adequacy. From one side, there is a position that say adequacy cannot be reached by design, by binding rules. On the other side, there is the position, for example, by Antonio, who says, well, should be a more binding design about adequacy, otherwise adequacy will not be reached. So on these two positions, I would like to have some clarifications. Thank you very much.
Thanks very much, Marzia. Anki or Lise, feel free to go ahead.
I could start from the Swedish perspective on this issue of the definition of the collective agreement and the right to redress. When it concerns the collective agreement, I think that the social partners in Sweden are very free to decide what shall be regulated in the collective agreement, how it should be formulated, how it should be framed. The only thing we find in Swedish legislation today concerning collective agreement is that it defines a written document signed by either a trade union or workers' representative organization and an employer or an employers association concerning the relationship between the parties or the employer and employees. But the definition of collective agreement in the directive, the social partners in Sweden fear that this would generate also court cases in the European Court of Justice or European Union Court of Justice on what a collective agreement is. And as such, it could interfere in the structures in Sweden by a preliminary ruling that provides clear guidance on how is a collective agreement to be understood. I think also the Parliament amendments included some kind of definition involving also a collective agreement being a document through which wages are regulated or expressed. And this for the Swedish partners would be highly problematic in relation to the numberless agreements where wages are not really defined in terms of figures or numbers. So those are the concerns. But if that is assured to be not strictly defined or formulated in a manner that would raise such risks of interpretation by the Court of Justice, then it should not be problematic, in my opinion. As concerns the right to redress, the very worry here among Swedish social partners is that this clause in some way or another would end up being interpreted as assuring an individual right to a minimum wage protection. Because as I tried to explain in my presentation, in Sweden there is no individual right, since we do not have minimum wage protection if there is no collective agreement in the workplace. So if the right to redress would be interpreted as an individual right for some reason, that would be very problematic. And that is the concern from social partners in Sweden. Thank you.
Thanks, Anki. Lise, please.
Just not to echo what Anki just said, but we have exactly the same concerns. In relation to the first question on the definition of collective agreements and what has been negotiated, we've been very worried that the term workers' representatives has been used instead of trade unions. And that is because, I mean, trade unions in Denmark are the official trade unions, and then I think around Europe you have a competition of organizations who are not really trade unions, but only basically insurance companies, so to speak. So I think for us it's really important that the directive states that the organizations negotiating collective agreements are trade unions. So that's the question of the definition. And in relation to the second question, and also the individual rights, we've also been quite worried. And I think I remember in the Council Legal Service statement in relation to the directive also said, and that was in footnote 30, and we looked at that very thoroughly, that there is no legal base in this directive if it gives workers individual rights. Then you go beyond the legal base in Article 153.5. So that's very important. We believe the directive goes beyond anyway, but the Council Legal Service has sort of that marked that red light. But we'll see.
Thanks, Lise. It's undeniable that Article 3 on definitions. We see what comes out from the trilogue, but it's undeniable that Article 3 defines crucial terms like collective agreements, but also it defines what statutory, what minimum wage is, and it seems to do it in a very, I mean, it's very difficult, the definition as it stands now, because it says minimum remuneration that an employer is required to pay to workers for the work performed during a given period, calculated on the basis of time or output. So it seems there's a 100% synallagmatic nature of minimum wage, which is not always the case, of course. So, and more in general, the definitions in Article 3 are particularly critical. But then you mentioned also, you both mentioned again, the functioning of Article 11. And I believe this is well, to be honest, when I first read the directive, I was not captured by the effects, by the potential effect of Article 11 on the individual right to redress. But apparently is a matter of concern. It's a serious matter of concern for the Nordic states. So once again, well, the text as it is now, it seems to leave untouched the ability of collective actors to go on behalf of the worker. So maybe my question to you would be, what would be so harmful if the worker had an individual right based on the directive's provisions? I mean, I can get that there's an issue of monopoly of enforcement, but I don't see why the individual right to redress excludes the position of trade unions there. Does it? Yeah.
I believe it does, because in our if you give an individual worker the right to redress at the national courts, you are shortcutting this conflict resolution system that has been well functioning for 125 years in Denmark. Then suddenly you will have the national courts involved in wage setting. So you cannot have two systems living side by side. When you have a collective agreement, you will solve the problems at the suitable levels according to the collective agreement and the redress system decided by the social partners. So the whole point of not having a directive is also not having the interference of the government, of the commission, of national courts, because our system works.
Anki, would you like to react also? Or?
I think basically what Lise expressed is more or less the same position as the Swedish social partners would hold on this, that there is a risk that individualizing the right to redress in this sense would also create a form of undermined sort of basis for the collective bargaining structures as such, since the individual workers would then not be in need of support from the trade union to protect their interest in such a case. So yeah, I think it's more or less the same for Sweden, yes.
Thanks. Can I ask myself to Emanuele and Torsten? It's kind of the same question, and it goes on the personal scope of application of this directive. Now, you both mentioned that the personal scope is simply copy-pasted from the latest experiences, the Transparent Working Conditions Directive. But how does it really work here? Because that definition of worker, well, it is like this because it's a compromise definition, but it tends to facilitate the purposive interpretation of the text of the directive. How does this differ in our case in the minimum wage directive from previous directives or from the previous case law, which is already there? If there is any difference.
That's a highly legal question, which I leave to Emanuele as the lawyer here. But I want to address a question by Marcia on the adequacy and the strength of the adequacy criteria. I think the problem we have here is that the more binding you make these adequacy criteria, the more difficult it gets with a legal basis, because that would be then you would be in the field of interference in wage setting if you make these strongly binding. And so in that respect, you have those 4 criteria that are in the proposal already, and it's clearly said that the priority of each of these criteria, or the choice of the criteria, is up to the member states. And then we have this double threshold, 60%, 50%, with which we discussed, which is either in the recitals or in one of the 5.2 or whatever. And I think it's very important to recognize the nature of this directive. I think it will not solve any of the problems, for instance, in the Eastern European countries we have, the direct procedures in industrial relations. I think this directive gives a tool to the national actors, which they can then use. And I think that's how I understand it. And if we get this double threshold in there, and either in the recitals or in the text itself, it's just another normative frame of reference, which national actors, in my case, of course, the unions, which the unions can use to strengthen and to increase the minimum wages. I think we cannot expect that this by the pure force of law will change that much. It's still a tool for the national actors, which they have to use in their national interaction processes. But if there is a strong double threshold in the text, that would be best, but also in the recitals, it's something they can use in the national interaction, however they set the minimum wage, either in a minimum wage commission or even in negotiations, where they can refer to, look, in this directive, there are internationally recognized standards for adequacy, and that's what they can use in the national context. I think the crucial battleground will still be the national level, and this directive just provides another tool set for the national actors to improve their situation, both in terms of minimum wages, but also in terms of collective bargaining, with a 70% threshold where they can demand action plans. And then let's see if the parliament succeeds in getting in some anti-union busting measures in the catalogue as well. That should be considered in the action plan. But it's, once again, it's a tool set to be used by national actors. And that's why I think we cannot expect the adequacy criteria to be very binding. It's just a tool set, and then it depends on the national power structures and power interaction processes, how the national actors use this tool set in order to improve the situation at national level. That's just what I wanted to add. Emanuele, you are much more capable in addressing the question asked by Luca.
Thank you, Torsten. I do hope so. So basically, I don't see any difference with the former directives. I mean, with the one on transparent and predictable working conditions and work-life balance. My guess on the scope of application is that when the European Court of Justice will have to interpret the scope of application of the directive, the European Court of Justice will follow the clear, coherent path that has been followed so far in providing a concept of worker which is broader than the national concept of employee, especially because the concept of direction has been watered down into something more, something closer to the concept of coordination. So all the workers that are in some way functionally and operationally dependent from the client are included into the concept of worker. So my guess is that the European Court of Justice will follow his interpretation. So far, there was only one, say, bump on the ride with the Yodel case, rather disappointing Yodel case, but that was the only one. So I think that the reference to the concept of worker, to the jurisprudence of European Court of Justice, will provide a quite broad scope of application to the directive. So the minimum wage will be addressed also to solo self-employed, especially in connection with the guidelines that the European Commission is providing on the application on the guarantee of the right to collective bargaining also for solo self-employed. So I think the trend is going to be there, the same trend of the former directives. Thank you.
Thanks very much. Antonio, you're the only one who did not react so far. Would you like to say, to react?
Well, not really. Just to note that what Lise Lotte observed about worker representation as against trade unions, indeed, in the amended version, at least of the Parliament, the word workers' representation in Article 3 has been substituted with trade unions. So we don't know if or not the trilogue will accept. On the impact of the directive, I would say that I would bet that there will be an impact on some statutory minimum wage countries, and in particular the Eastern countries, let's say new accession countries, Greece and Portugal. And this is because this system does not guarantee the necessary involvement of social partners, I think Article 7. And this is quite paradoxical because Greece and Portugal do not have a social partners involvement precisely because the union with the Troika obliged them to do so 10 years ago. That's all. If I may add just a personal note, I'm very happy about this seminar because talking to Lise Lotte and Anki, we always discuss about the Nordic opposition. It's kind of mythological position, the Nordic opposition to the minimum wage directive, which from our point of view is not difficult to understand. It's perfectly understandable, but it's quite far from our perspective for the reason I tried to talk. So, and I guess that both of you have given us a very strong instrument to understand what's going on in systems which are lucky enough to work smoothly and well, which is not the case everywhere.
Thanks, Antonio. I fully agree with this, and probably the involvement of a wide range of experts in this seminar was indeed a good start to go on with the debate. Now, we didn't know at the time where we established the date, we didn't know that next week will be probably the final stone on the edifice of this directive. We will see if this happens, tant mieux. If not, we will see what happens in the next episodes. But again, I think that as a community of labor lawyers, we should keep the debate open and see what will happen in the next future, both at national level and having the text of the directive in front of us. So thanks very much. It was 2 very, very nice hours of discussions and debate. Thanks to the labor law community. Thanks to our wonderful speakers of today. And I wish you a nice evening and hope to see you back here in the next labor law community seminar. Bye. Thanks very much.
Thank you. Ciao.
Bye-bye.
Bye-bye.
For those who are running the platform, I will stop live streaming now, and then I will also stop recording now. Up.